Alexis.
Yeah, good afternoon to the UCLA Anderson Alumni Network. Hi, I'm David Cooley. I'm the Director of Alumni Career Services in the Office of Alumni Relations, although remotely, like most other people. Really happy that you could join us today. We know that the year is winding down, a very, very strange and unsettling year, but happy that there are still offers being made. There is a lot that is still happening for the people that are really getting out there. And I'm really excited about today's webinar presenter, an attorney named Catherine Rhodes. Catherine and I met through a series of mutual connections. Catherine's got a strong background, which she'll tell you a little bit more about in just a few minutes. But what we're really going to focus on today are employment contracts. As you know, the title is called What to Know When You're Beginning or Ending a Job. And so a lot is always important to consider before beginning or ending a job. But what Catherine's really going to get into today, and Catherine, if you could just share a little bit about your background, and then we'll get into 5 things that you need to know with both starting a job and separation agreements. So Catherine, tell us just a little bit about your background.
I am an attorney. I've practiced law for 29 years, and it's been pretty much exclusively in employment law. I was a litigator for many years. And about 5 years ago, actually 5 years ago this June, I went on my own and opened my own practice. And I specialize in representing individuals in the employment context, whether they're starting a job, they've lost a job, they're transitioning to a new job. And that's been my area of expertise: compensation disputes, harassment, discrimination, anything that can happen on the job, I can handle it.
And we really appreciate that. These are insights that we don't always hear at UCLA Anderson. Sometimes not until it's really not too or it's too late. And so let's jump a little bit into, first of all, a little disclaimer. Catherine, you want to talk quickly about what we're going to talk about today?
Well, we're going to discuss 5 tips for looking at an employment contract and 5 tips on what you should be looking for in your severance agreement. I want to be sure that people don't take this information we're sharing today to be, that you're my client. So if you have a question, call me, but please don't take any of this as legal advice that would create an attorney-client relationship.
Yes, and Catherine's contact information will be available later on. We do encourage you to send your questions throughout the session. We'll start answering those questions at about 40 minutes to the hour, if not a bit earlier. So we have a lot to go through. So let's start with 5 tips on what to look for in new employment contracts and 5 tips what to look for in those separation agreements. So we'll start with number 1. Catherine.
Number 1, you guys can all read the PowerPoint presentation. It's exciting when you get a new job, and particularly in this climate we're finding ourselves in now, people are a little scared, they're a little frightened, they're a little nervous about what's happening with the economy, and so they're anxious just to get started. And so the tendency then is to just accept what the friendly HR person reads to you, what her little summary or his or her summary is, and not ask questions about what, and not thoroughly understand the agreement. So my point for this tip is that, especially if it looks like boilerplate language, you should really read through it and understand it before you sign it. And if you don't understand it, there is no shame in asking a lawyer to explain it to you. If you didn't understand your house real estate documentation, you would have no problem going to a realtor and asking them to explain it, right? Or any other area of expertise. So much like this, it's better, in fact, to educate yourself so that you can make a good decision and know what you're getting into. In this context, some employment agreements I've been seeing in this time that we're living in, where it's a little bit like the Wild Wild West out there. Employers are nervous, employees are nervous, employers can be a little overreaching. They're not trying to be evil or anything, but they're trying to protect themselves, and sometimes they go a little overboard, let's just say. So when you read that employment contract, be sure that you watch for overly broad or overly burdensome restrictions and negotiate to have them modified. Now, California, as I'm sure you all know, is particularly hostile to non-compete and non-solicit agreements, but that doesn't mean someone won't try and sneak it into your agreement. So watch for it. It's easier to get it removed on the front end than on the back end. And frankly, even if it's unenforceable, get it corrected anyway, because you don't want to give the employer an edge down the road. Well, will you sign this? And it says blah, blah, blah. And why put yourself in that position is my point. Other things that I've been seeing in agreements are a non-compete or a non-solicitation agreement that lasts for more than a year. Just watch for that. Another thing I've been seeing are non-solicitation agreements that cover areas where the employer does not do business. Another thing to keep an eye out for. There might be a non-compete that is included in your agreement that might potentially interfere with your ability to find a new job or a new gig in your chosen field. So an example, I have many marketing people who come to me with employment agreements, and they say, well, this looks pretty good. I'm in between jobs. I could make like, 20 grand. What do you think? And I said, well, I think that you should read it really carefully and make sure that you don't accidentally step in it and get yourself into trouble. I had a client who had such an agreement, and buried in the PIAA agreement, which is, I can't remember what that acronym stands for. It's Proprietary Information and Inventions Assignment. But buried in there was the definition of the company that she couldn't work with that included anybody related at all to Comcast. And she's like, well, I didn't know that was there. I'm like, well, now you do. And maybe you should think about why that would be a bad idea, because you would restrict your ability to find new employment. Other things that you should watch for are expansive arbitration agreements. So there could be an arbitration agreement, you'd find it in your agreement, that would require you as the employee to pay for the full cost of the arbitration. You don't want that. You either want to split it, or you want to insist that the employer pay for the costs associated with arbitration. And as a last thing to look for, some arbitration policies, I've seen them now, they are inserted into the agreement and they are designed to shorten the time frame in which to bring a claim like discrimination or harassment. So an employee in California now has 3 years to file a complaint with the DFEH for unlawful discrimination, harassment, retaliation, other unlawful conditions, but sometimes employers try to shorten that window, and that's a potential area that you should keep an eye out for. All right, tip number 2. So what this is about is and how it's coming about now is that Company A is selling to Company B. There's a lot of this going on right now in the marketplace, right? So what Company A says is, I will give you a retention agreement. And in that retention agreement, there will be buried a waiver of any claims against Company A in order for you to sign on to be an employee of Company B. And the problem with that is that if you have any claims against Company A, like harassment, like some sort of compensation dispute that didn't get resolved, that could increase the value of your retention agreement paid by Company A, you will waive it if you sign that waiver. So you need to be very careful about that. You don't want to be boxed in to having to arbitrate legal claims down the road or claims that you might prefer to litigate in court. So you might just well have to sign it, because they're like, look, you're not the 800-pound gorilla. We're not going to change this boilerplate language just for you. But what you can do in that instance, which is smart, is ask how the company is generally enforcing that, particularly if it's a non-compete or a non-solicit provision, because it'll help you anticipate issues down the road. My whole point of this presentation is educate yourself on the front end so that you know how to negotiate and put yourself in a better position later, should you be under the very unfortunate situation of being laid off or suddenly lose your job. Okay, tip number 3. Okay, this seems really obvious and seems really basic, right? But everybody is excited. They just want to get in there and they want to get started, and they don't want to make any waves. They don't want to seem like a problematic employee, a complainer, a wheel squeaker. So they say, fine, whatever you want. I'm just so anxious to get started. Thank you for this opportunity. And they don't keep copies of everything at the front end. And stuff like your employee handbook, your contract, your stock option agreement, things that kind of, or even performance reviews as you go along. Keep copies of those, because with respect to the employee handbook, why it's important to have it handy is that it contains policies and information that you might, God forbid, need down the road. Let's say hypothetically, you're doing a great job. Everything is terrific. Suddenly someone accuses you of harassment, right? For example, and it's totally not true. And I had a client recently, this happened to her. It was a witch hunt. She was completely set up. She did nothing wrong whatsoever. But buried in that employee handbook, which she had a little difficulty getting a hold of, was language that was helpful to her in terms of taking apart and dismantling the employer's allegations that they made against her. So if the company handbook says something like, cultural values of our company, we try to work everything out. We don't want everyone to get really excited and run out and sue us. So let's try and work it all out. We're very pro-employee. Language like that can be used in connection with the negotiations to get her a better severance agreement, because they're supposed to be working it out, not just hanging her high, so to speak. And that's just an example, but once your employment has been terminated, it is really difficult to get your hands on these documents quickly. And as a side note, in California, everyone, as a matter of law, is entitled to have access or be provided copies with most of the things that are in your personnel file. Get to know your personnel file. It's kind of like your credit report, okay? Check on it regularly. Make sure there's nothing scary in there, something you didn't anticipate, something you didn't know about, right? And so what my point is that should you be terminated, you can ask for this report, and I'll explain how to do that a little bit later. But sometimes when you're in the middle of a severance package negotiation, it'd be really helpful to have had all that information at hand, so you don't have to wait 30 days to get the documentation. So it's 30 days for them to give you your compensation and other related documents, and it's 21 days for the payroll records. But if you don't really want to wait for that, if you keep a running track record, or keeping a live file, if you will, of your own as to what's in your personnel file, that will enable you to be better prepared should something disastrous happen, like you should lose your job and you need to negotiate a package. Lastly, another thing that you should keep your hands on are copies of any documents that explain how you are compensated or paid, stock option agreements. Make sure you keep copies of those so you have them handy. Sometimes they're hard to get a hold of. So one more point that I don't want to forget to say is that also in connection with this tip number 3 of getting copies of all your agreements, you should also really understand very clearly what will happen, how you'll be compensated if your employment ends under different scenarios. If your employment ends pursuant to a layoff, you get X. A termination without cause, you get Y. Termination with cause, you probably get very little. Or you quit or you resign. It's really easy to ask about how this all works at the front end. Tell them you want to make sure you're in compliance with everything, that you understand everything, that you're a really team player, whatever you need to say in order to get the information, right? It's much better to have it up front. Okay.
And by the way, some questions are coming in. Please feel free to continue to ask your questions in the Q&A section, but we'll keep going in the meantime.
Okay, great. I'll be happy to. I think David said at 12:40 we're going to start answering questions.
Yeah. Thanks, Kathy.
Tip number 4. Oh, I started to talk about this, release of claims. Actually, I accidentally talked about it earlier. I think I already talked about this, but so we can move on to tip number 5.
Fair enough.
Oh, this is so important. I can't emphasize this enough. If it's important to you, get it in writing and get it in the employment contract. Particularly in these times where employees are working remotely, make sure that your arrangements are articulated in the agreement. I had a client who worked for a large company. She was an IT consultant. She had her own business. She was told she could work 2 days a week at the company and 3 days a week at home. And she got the contract, and those terms weren't in there. And she said, well, what do you think? I mean, it's not such a big deal, right? I mean, the branch manager promised me this. And I said, what the branch manager promised is worthless. It needs to be in the document. What if that guy leaves the firm, right? And then your deal with him, this kind of on this side deal, which technically isn't enforceable because the employment contract specifically states on its face that this is everything. This is the whole enchilada. Anything that you worked out and was promised to you by your employer should be in that document. What other types of things should you consider including in your employment contract? I'll give you some suggestions, right? First off, it should be anything that's important to you. Don't think it's not a big deal, so I shouldn't include it. This is your job and your career, so include it. If it's about location, I work for Tesla. I don't want to ever have to move to Texas, for example. I'm a California employee. I live here. My family's here. I'm staying here. Number of hours for those of you who are consultants and you own your own business. Articulate that in the agreement. I'm not going to work more than 45 hours a week, or I get some special extra compensation. The type of work, make sure you're not someone's personal slave. I hate to use that language, but it's true. If you have an open-ended, I'm a consultant, they could end up asking you to do anything, staple documents. So be really specific about what your job description is, what your title is, what your responsibilities are. Who you report to. This is a very interesting side note. I have a lot of C-suite clients, and it's critical for them that they report to the CEO and not the CFO. And it becomes an issue because you don't want to have to break through the firewall of the CFO to get to the CEO on something that you want to get done quickly. So if it's important, include it in the contract. And if you're that big of a player, you could definitely negotiate for that language. Don't give up until you have got it, until it says what you want it to say. How often you receive a performance review? This is another interesting question. I can't tell you how many clients I've had this year who said I was supposed to get a review in April, but the pandemic happened and so we deferred it. And now I'm getting laid off and I don't have a performance review. I said, well, that's a problem a little bit. I mean, you have a great performance history, but it would be really awesome to have this performance review included in your personnel file. So, word to the wise, in your employment contract, even though it says it in the employee handbook that you will receive an annual performance review, put it in the document. I'm going to receive an annual performance review executed by my boss on the 15th of April every year. Just put it there, and then it will be in writing, and then you can enforce it that way. So the HR person says, well, you know, there's lots of things changing, and so we can't do it this year. You can say, well, but I'm special. It's in my employment contract, and I need to have this performance review conducted now. What else can you include in there? Well, we all have 20/20 hindsight, right? Severance pay would be great. If you're laid off within a year of your employment, or you're laid off within a certain time period through no fault of your own, put something in there to the effect that you get a year's severance. It's really hard to get a job right now. So it would be great to be able to have that money and have that included in your employment contract. Fringe benefits. This is interesting. More C-suite employee stories, but often the language in the agreement says you'll receive the equivalent insurance of the same level employee as you. Well, what if your job changes? And what about if you have a big family and you'd like to have not only health insurance, disability insurance, life insurance, vision insurance, and dental insurance? Why don't you include all those 5 things in your agreement? And then there's no issue. There's no dispute. It's all in writing. Another thing you could include in your employment contract is a change of control provision. So much like where you go from company A to company B, if something like that happens and you don't really want to go to company B, right? That's not a good place to work. You have created a backup plan for yourself, a chunk of change that you can use while you pivot to your next position. Watch the definition of termination without cause to include something you might anticipate, like a company moving. I refer to Tesla again, because who thought that they would move to Texas, right? And you don't want to move to Texas. So include something in there that would trigger a graceful exit for you to leave and receive severance, and everything would be copacetic. Sometimes you can negotiate. Sometimes you have to be a pretty big player for this, but to have the company reimburse you to have a lawyer read and negotiate your agreement. What I suggest is that you cap it. You say in an amount not to exceed $5,000. And then what you do once you're hired is you submit that as an expense. I think that's very clever. I'm all for that provision. And Lastly, make sure your employment contract, the law that controls the contract is the law of the state that you're working in, California, for example. California is very pro-employee, so make sure that it says California law. All right, how are we doing for time here, David?
We're good. We're good.
Okay, right on the money, 12:20, perfect. All right, tip number 5. Oh no, we're moving into severance packages. Tip number 1. All right, don't laugh. I know this is, we're trying to add a little humor here. Now, the point of this cartoon is that you were just laid off, you were just fired, you just resigned. My suggestion is this is a very traumatic experience. You sit down and you write down what happened. You write down what happened from when you first accepted the job, what representations were made to you about that job, if it was accurate, what happened over the course of your employment, both your accomplishments, the good, and the negative stuff, the ugly and the bad. And the reason this is important and the reason this is a good tip is that you don't feel so great when you just got laid off. As a matter of fact, you feel like you just got hit by a car, right? And so you're not even thinking very clearly. There are a lot of things running around your head. You're upset. It's traumatic. And the best way to get yourself back in the saddle, so to speak, and no offense about all these cowboy references here, but get yourself back in the saddle is to write it down. And then you can kind of start to see the forest and where you're going and distinguish what's happening and make a plan as to how you're going to proceed next. In effect, it makes you feel better because you don't have to replay this scenario again and again that you've already probably shared with your family, with your friends, with your colleagues, how traumatizing this was. This kind of gets you into the next headspace where you are so that you can figure out what you're going to do next. And me personally, as an attorney, I always ask my clients to do this. And I said, look, it doesn't need to be Tolstoy. It doesn't need to be 80 pages long. I just want to see how you write. I want to see what your version of the facts are so that I can evaluate. It's part of my judgment as to how involved that client could be in terms of negotiating on their own behalf. I just kind of want to see how they see the world, how they saw what happened. It educates me as to how best I can help them. All right, tip number 2 on severance agreements. Okay, I kind of said this already once, but if you don't sell your own house, you don't write your own will, you don't prepare your own divorce, there's no shame in getting a lawyer and figuring out what to do in terms of how can I best arm myself for the best severance package ever. As a matter of fact, any lawyer worth their salt, myself included, will give you some of their time to evaluate whether or not it's a good fit, whether you should retain them, whether or not they have the ability to move the dial. Maybe you don't need a lawyer. Maybe it's very cut and dry and there's no need to involve an attorney. But lawyers are actually good people. We are actually educators. It's our job to be sure that the rules are enforced and use us. We know what the rules of the game are. So educate yourself. Find a lawyer you like, someone that you trust, because you don't want to hire somebody who you don't want to follow their advice, right? So find someone that you like who can guide you through this process. I know you all went to business school, and so it seems like this could be really easy, but I encourage you to seek out the assistance of an expert. You won't really know what's important and what isn't. Let's say, for example, can you all tell me what the pieces of a cause of action for harassment are at your employment? You probably wouldn't be able to identify all elements. So you're in a really awful situation. You've been let go. It's hard to even think clearly as to what happened. Get someone with a clear head and understanding of the issues to help you get through this process. Okay, tip 3.
Sorry, I'm stuck here. One quick.
That's all right. I can't say this enough times. I can't tell you how many people call me and say, I've got this offer. Do you think it's a good deal? Should I take it? And I said, well, let's talk about it because it's just an offer. You have to respond to this. So what's the worst thing that could happen to you? You're already out of a job, right? They're not. In 29 years of practice, I have never seen a company take a severance offer off the table. The very worst thing that's going to happen is they're going to say, this is not negotiable. Take it or leave it. This is what we're offering. And then you'll know, at least you tried, right? The second thing you should do when you get a severance offer is you should read the fine print. And if you don't want to read it, you should get a lawyer to help you read it, and so that you thoroughly understand what you're getting involved in. Okay. The third thing is, again, relating to being traumatized. The guy just walks into your office. He says, I'm sorry, we're going to have to lay you off. Here's a severance package. We're offering you 2 months severance. Think about it and get back to me. And we're going to have you clear out your office right now. Can I tell you, this is like one of the most traumatic experiences of your entire life. Clients tell me they feel like they did something wrong. They feel like they're a criminal, and they want to get the hell out of Dodge. They want to get out of that office so fast to make your head spin. They're embarrassed. They're humiliated. It's an awful, awful experience. But do not sign that document right then and there and run out the door, right? Take it home, review it, get a lawyer. Most severance packages give you a review period of at least 21 days. You have time to figure out how to respond, okay? So arm yourself with that. You can even sometimes get more time than's actually offered in the face of the severance package if you ask. So very important, take a deep breath, take a couple days, cry, scream, do whatever you have to do, take a long walk, and then start thinking about how you're going to respond to this particular situation in a business-like fashion and get the best deal possible. Fourth part about this severance package as an offer is you need to know how to negotiate. Now, I know you all went to business school, you all know how to negotiate, but it all depends on what else is on your wish list, I like to say. You all know that if they say 6 months, and you want a year, you don't say, give me a year, right? You all say, no, I want 1.5 years because I'm going to, negotiate to come back down to the middle where I want to be. But another thing to think about, in addition to the actual number on the severance agreement, are all the other things that you could also ask for that could make a really good package for you. It's not only about the number. And what I say about that is, let's say what's really important to you. Well, let's say the number is really important to you, but the health insurance isn't, because your partner or your spouse or your significant other or whatever has the health insurance covered, right? So you can afford to give that away. So you could come back and say, I want 1.5 years severance and I want 1.5 years of health insurance, because you're going to throw the health insurance out the door anyway. And the employer may say, well, we can't afford to give you like 1.5 years of health insurance, but we'll give you a year's worth of severance. And there you go. You've got what you wanted. I think it's really important to make a list, ideally with your lawyer, of what things you really want out of the severance. It's not an easy road. It's more productive and healthy to have someone on your side advocating for you who is not emotionally involved in the process, right? Those are my points about negotiation.
Well, it's safe to say, Catherine, that this is the most vulnerable time. I think there's so much mystery around what you're actually able to do and not able to do. And this is happening to a lot of people in a lot of different industries right now. So just to expand on that again, when you say negotiate it, what are the biggest things that people leave on the table? And we'll go to everyone else's questions in about 10 minutes.
Okay.
But I know you've got more to cover, because I know this is something I get asked quite a bit. What are the things that people leave on the table? Is it really additional time, additional compensation? What have you seen?
Well, actually, that's tip number 5, and we can jump to that if you like. But it's what else can you negotiate for in addition to increasing your dollar amount?
Perfect.
There are the items right there, and we can go through them. People often forget that the company has an outplacement service. They have a contract with a third-party outplacement firm. Employees forget to ask. Well, I could use, $5,000 worth of help from Lee Heck Harrison. And the employer will say, well, sure, we can give you that. That'll help you tighten up your resume, practice your interviewing skills, and you can start targeting who you want to be employed with next. Another thing people leave on the table is it's possible to ask, always ask, transitional agreements or consultation work. It may not happen, but if there's a layoff, maybe there's an opening for you to be a consultant. And to that point, be very careful that you negotiate for the appropriate hourly rate. I had a VP of a credit union. He was all excited. They offered him a transitional compensation arrangement, but he said that they're only offering me $50 an hour. I said, well, do the math. You made $190, you're working 2,000 hours a year. You should be getting at least 95 an hour. So change it. Another thing people leave on the table and don't think of are lump sums versus installment payments. Talk to your accountant, figure out what best works for you. But I have some clients right now I'm representing, the company merged, and the company offered to break the severance payment up into the equivalent of kind of offering them 2 weeks of pay every 2 weeks, but it was a small amount, right? Because the severance agreement is not equivalent to your salary. But while that's happening, while they're still on the company's payroll, they can't apply for unemployment. So it's better to get the lump sum payment up front. And again, take all the income in 2020 and immediately apply for unemployment versus dragging it out into 2021 and then getting the lump sum there. Whatever works best for you. These are kind of things people leave on the table. You asked me more very specifically.
Great.
Be creative. This actually happened to a client of mine. The childcare that the company offered, her daughter was going to be not be able to finish preschool. I said, well, let's include that in the negotiation, and they gave it to her. She was very excited. So was the little daughter. Mutual non-disparagement. The agreements often provide for you not to badmouth the company. Well, I don't see any reason why this shouldn't go both ways. If you're going to part company, everybody should go off from their merry way. There should be no bad mouthing of anybody. References. You figure, oh, I know a lot of people at the firm and surely people will speak well on my behalf, but the company may put the kibosh on that, right? They want to silence anybody from speaking about what happened or what their circumstance under which you left the firm. Are you moving on to Q&A, David?
No, apologies.
Okay.
This is the downside of
That's
sharing
okay.
my screen. I'm sorry about that.
No, it's okay. But a reference is a really good thing to negotiate for. I would even go so far as to say the reference letter will be written by Mr. Smith and I will receive it by the 15th of December. I would put a date in there, right? Sometimes you say it's going to be written and then you leave and then they forget about you. Legal fees, sometimes you can get that in there too. In some cases, the company will pay to have the agreement reviewed. Again, I suggest with a cap on fees. A company property, keep your laptop or your phone. People think, oh, they send the FedEx box, right? You pile your crap in there and it leaves, but the company really doesn't care. They can clean it up and you can keep it and it saves you a trip to the Apple store. And lastly, limitations on cooperation clauses. People just sign on the dotted line and it says something very broad like, should investigation or litigation occur, you'll cooperate and come and help this company that just let you go to the ends of the earth to defend itself against litigation, which maybe you don't even agree with. So get it, don't have it be open-ended, get reimbursed for travel expenses. You could even include language that says you don't have to drop everything in your new job to come help your prior employer. And you could even negotiate an hourly rate. So this is not a comprehensive list, but these are the kinds of things that people don't think about adding to their severance package. And I guess we could go back to tip number 4 if you want, but I've already told you that you should request a copy of your personnel file. If you don't already have it, you should get it. What I was going to add here, if people are taking notes, this is readily available on the internet, but anybody can ask for their personnel file. Anybody. It doesn't need to be a lawyer. It should be in writing. You should basically just say, well, before I tell you what you should say, you should know what could be in there that could be helpful, like excellent performance reviews, information that contradicts what the employer is saying that are the reasons for letting you go, which can set you up for a nice constructive discharge claim, right? Wrongful termination. If they can say, it's an at-will state. You can be let go for any reason or no reason at all. I had a bad cup of coffee this morning. I don't want to see that person anymore. You're fired. That's fine. But if I make up a reason for letting you go, oh, it didn't really work out. Your writing is awful. And then my performance review says my writing is terrific. Well, that's a nice setup because you just found a reason to say that you were constructively discharged. They made a pretextual excuse as to why they would let you go and didn't set forth the real reason. I can go through how to request the employee records if you want. It's really easy. You just send a letter to the Human Resources Department and say, I request a copy of my employment records maintained by the company, that relate to my performance or any grievance concerning me. That's Labor Code section 1198.5. Any instrument signed by me relating to obtaining or holding employment. That's Labor Code section 432. and all my payroll records. That's Labor Code Section 226, subdivision B. Again, I have to emphasize that you're in a little bit of a tight spot because the employer has the advantage that California law gives them a certain amount of time to compile that. You got 21 days for payroll records and 30 days for the rest of it. You could try to sweet talk the HR department, make them feel sorry for you, try anything to see if you can get those documents, but better if you've been kind of keeping tabs as you went along and you created your own personal copy of the personnel file, then you will be ready for bear when it happened. All right. I think that's all I have to say.
All right, so we're going to jump into the Q&A, and because we're using my screen, I think people saw more of me than they wanted to see in the Q&A. What I'm going to do is I'm going to first very quickly show your information here, then we're going to come back to it later for a few seconds. But while you're taking a look at this, or maybe doing a screenshot of this, so you can reach out to Catherine. Catherine, can you talk just a little bit before we go into the Q&A of what you're willing to do? Just if people have these questions, because I see some quite a few questions coming into the Q&A, we'll jump into those sooner than we expected. But you mentioned that people can have a quick consultation with you before they sign. Can you talk about that?
Yeah, I mean, I'll talk to everybody. I'll give you 15, 20 minutes of my time. I'll hear your story. I ask you to write it up first so that I kind of have a sense. It's more efficient for me if I can read it quickly and know what the issues are and see if I could be of help. But I'm happy to speak to anyone. That's part of why I agreed to do this. I feel like people don't know that there is help out there for this kind of situation, and that you should really avail yourself of what's available. There's lots of great lawyers out there who can give you a hand with this situation, and I encourage you to seek them out.
And we really appreciate that. I'm going to jump to the questions. I'm not sure if you can see them. Brianna, can others see my screen? I don't believe so. So let's jump into the questions.
Okay. Full disclosure, I have not read the Q&A and I have not been keeping track of the chat. So
no, fair enough. I'll read them to you. First
Sure.
one came in and said, does there tend to be any state regulations providing for minimum time to review an agreement? This person mentions that they had one company that asserted that it had to be signed within 48 hours, hardly enough time to engage an attorney to review.
I'd have to see the agreement, but I've never heard of such a requirement.
Okay. Next one comes in is, do we have the right to request a copy of the personnel file? I know you talked about that. And also, do employers keep personnel files of contractors?
Sometimes they do. They have a contractual arrangement with the contractor, so it's possible. It'd be worth asking. They're not technically employees, so I'm not sure. I have to look that up. Whoever has that question, call me. I'll look it up and figure it out for you.
Terrific. Another alum says, I just found out that my job will be terminated in 3 months. The entire team is being laid off. HR at the company is very unfriendly and cares little about employees. What are the options if this person's not being helped to get the document access?
Well, are they just asking for the document access, or do they put it in writing? Put it in writing, and then the employer is on the hook to respond it under the labor code. So don't make an oral request, put it in writing. Then you can keep track of how long it took, what's going on. That's what you should do.
Okay, fair enough. And to continue, the next one is regarding the various requests to get opt out of something or change or remove the non-compete, to add severance language and performance review commitments. Isn't there a big risk that the employer will conclude that you are too much trouble and take back the offer? How do you navigate this smartly? This one is really important. These are all important, but this one I hear.
It really depends on the job. It depends on the relationship that you have with the employer and how big of a player you are. I mean, honestly, the 800-pound gorilla can put whatever he wants or she wants in their contract. I don't think that things that are legally enforceable are a problem to ask for. You could tee it up by saying, I'm just wondering why there isn't language in this agreement that says X, Y, Z. Is there any reason why it's not included? Put it back on the employer to explain why it's not in the agreement, as opposed to asking for it outright, making a demand. Say, it's funny, this agreement doesn't include X, Y, Z. Is there a special reason why it's not included there? You just negotiate it.
Great to know. Next question. Quite a few of them, and a lot are just coming in. So we've got
Okay.
lots to talk about. An alum asks, in the situation where your client was falsely accused of harassment,
Mhm.
can she sue for slander?
She certainly could, and that was a consideration. What did she want to negotiate an excellent severance package, or did she want to bring a lawsuit? And that's a conversation I usually have with my clients as well. I've had clients who didn't want to sign a severance agreement and they want to just go on a full out outing experience. I had one client who wrote a big, huge article about all the awful things that happened at this startup. She's like, I don't want their money. I just want everyone to know that this is a bad place to work. And as long as it was true and it wasn't defamatory, she was well within her rights to do that.
Great to know. Next one is there anything that we can negotiate in employment contracts regarding shares slash options at a startup company? The shares are worth nothing when joining the company. Normally, you can retain nothing when you leave for whatever reason. However, the startup companies pay significantly less than market rate and then dangle the share options
Right.
to make up for it. What are your thoughts on that?
Well, what was the question? Can you negotiate them? Yes, you can
Yeah.
negotiate anything, but what specifically are they trying to negotiate? Or maybe you should send me the agreement and we could talk about it. Whoever asked that question, I'd be happy to talk about it with you.
Yeah, regarding shares and options for a startup specifically.
You could put triggers in there. You could put time frames on when they vest, earlier vesting dates. Again, with like change of control provisions, or something happens, something you anticipate might happen. Shorten up that vesting period so that you get it. You don't have to be there a whole year. This happens a lot. A lot of my clients are like, I'm only here because of the stock options. The thing's going to go IPO, and I want to be, I want that chunk of change. So if you can shorten that time frame that you have to wait for that to happen, that's one angle.
Mhm. And again, I know you can't answer every one of these questions specifically, but another question is what should you expect when hiring legal counsel to review your severance package in terms of fees? I imagine that's a private discussion, but in terms of yours versus a big company, this person says, I definitely had some HR issues and harassment issues that were brushed under the rug, and I want to leverage that during my severance negotiation.
Then you should call an attorney and go over those terms so that you can articulate your strategy and articulate which of those are the quote unquote sexiest. Sometimes something minor happened that isn't as powerful. You don't want to send a laundry list of like 10 things that happened to me and therefore I should get a bigger severance package. What you want are like 5 excellent big things that you can use to start that whole process going. That's in my opinion. And it's different for every case.
Another question that came in is the question is, what is a fair length of time for a severance? How is that calculated? This particular alum mentions that he's only been at a company that and has only heard 1 to 2 month severance offers. What is there a formula that tends to be used, or is it company by company?
It is company by company. As a general rule, it can be anywhere from like 1 to 2 weeks per year served. But again, it's going to depend too on if you have other claims that you could negotiate. If you have leverage, if you did something spectacularly special because of the pandemic. I have a client that happened to. He was asked to drop everything in order to help with this particular project. So you could use that to say, I did 2 people's jobs basically. So I should get 4 weeks, not 2, something like that. It really depends on the facts.
Okay, the
But
next one.
that's the general rule. It's 1 to 2 weeks. Now, but if you're looking for a ballpark number, that's the ballpark number.
Great to know. Can you talk about your experience of how in a mass layoff scenario and how that may differ in terms of leverage and strategy for negotiating severance? Certainly, the entertainment industry is going through a lot of that right now.
Right. Right.
So, can you talk about that difference in the leverage and strategy in terms of negotiating severance? And also, this person mentions that they were laid off from an industry decimated by the pandemic, and it didn't really feel like that person had much leverage. So, what are your thoughts on that?
Sometimes you don't have much leverage. I mean, that's part of like calling a lawyer and saying, so is it worth it for me to like try and move the dial, or is this kind of it? So it really depends on the facts. But yeah, I'm in. Sometimes it's not worth hiring a lawyer. Sometimes there's nothing. The company's going under. They're offering you what they're offering, and you can take it or leave it. But I would still push a little bit on outplacement services and some of those other things that were on that last slide. there are some things that don't cost the company a lot of money that are valuable to you. So even if you can't change the severance number, the dollar number, you could add these other things that add great value to you, like childcare, like a reference, like outplacement services.
Great. A related question in terms of the leverage that a laid off employee has in terms of negotiating severance, wouldn't changing the terms for one employee put the company at risk of discriminating against others who were laid off as well? So if they agreed once, will that affect anyone else?
It's confidential. They'll make you sign it. It's confidential. You cut a better deal than your buddy. Well, you were a little smarter.
Fair enough. And the questions keep coming in, and we still have some time, so feel free to continue to put your questions specifically in the Q&A section.
Okay.
Next is there anything specific to consider if your firm is in litigation with the new employer that you're going to be employed at in the future?
Yes. I think there's a lot of things.
Look at it.
I think that's a little too complicated to answer. I
Okay.
think you should get someone to look at the documentation from company A, company B, get a hold of the complaint. If there's actual litigation going on between company A and company B, show that to an attorney and get some advice as to how to proceed and protect yourself.
Okay, the next one is, what leverage do laid off employees actually have? If it was no fault of their own, kind of a variation on the prior questions.
What leverage do they have? Well, a fair amount. It depends on the paperwork. I had a banker who was laid off and he had a stock option agreement, and the terms of the stock option agreement were such that he wouldn't get his vested units until time after he had already been laid off. But we were able to I was able to read the stock option agreement carefully and determined that the committee who's in charge of the stock option agreement had a lot of discretion on how these units were vested. So citing that language together with the request, we basically said there's no reason, there's no cause to ding him or penalize him. He's done nothing wrong, great performance reviews. And in the end, he got his 6-figure stock option. So he was very happy. So that's the kind of leverage you can get. You don't think you have leverage until you talk to a lawyer, basically.
Absolutely. And that's so important. And I know you've worked with a lot of Anderson alums already, but this is related to one that you and I, Catherine, talked about back in June with that one.
Confidential.
Yep, we're just not going to say a thing about it, but it involves state law, right? The difference between the different states and their employment agreements. The question is, what state law is employee bound to follow if the company is headquartered in a different state than the employee actually works in?
If you work in California, you're a California employee and you're protected by California law.
And if the team's in New York, is what the person asks.
It would be in your employment contract what law would govern. But if you're a resident of New York and you're working in New York, then New York is going to, this is a tax question, really better directed to a CPA, your CPA or your accountant as to how that would work. But in general, if you're physically working in California and you're working out of San Francisco, then California applies. And that's the argument you would make. I'm sure the employer would try to say, well, no, the employment contract you says Massachusetts law applies. So, you can duke it out.
Good to know. I see some people continuing to ask things in the chat. Please put your questions over in Q&A. Specifically, we've got about 10 more minutes and quite a few questions coming in. The next one is, how do you approach your employer to ask for a severance offer if you've been told that you'll be laid off and the employer makes no offer at all?
That's an interesting question. I would like to talk to that person as to how that transpired. I think it's a little delicate, but I think there's a way to do it.
Terrific. These are very complicated, and you said state laws. You're specifically talking about California. You are.
Yes, I'm licensed to practice law only in California.
And the thing I referenced obviously involved another state, and so it got a little bit complicated. Very complicated, actually. And so we really appreciate what you're sharing with the UCLA Anderson Alumni Network. So we've got about 10 minutes left. What's the next question? What's a good rule of thumb regarding a pre-negotiated severance? 6 months? Some companies always just say 2 weeks, plus any outstanding vacation. You talked about this, but maybe we can expand a bit on pre-negotiated severance.
So the paid time off, the vacation, you get that automatically. That's not part of the severance, right?
Right.
So you're saying what's a good number to start with? Is that what the question is?
I think this person is saying when you're starting the job, if you're already trying to
Oh, right.
load in severance
You
based
want to put it in on the front end.
exactly. I
Well,
think he's
you
asking.
know, a year ago, I would have said, probably take 6 months to find a job. Now, I think it takes twice that. So if you were signing an agreement now and you had the firepower to ask for it, I'd ask for a year. If I lost a job, that's help. And I would ask for it. I would explain why. I would say because of the pandemic and because of the global financial situation we find ourselves in, it is going to take me a year to find a job.
Yes.
So I think if you not just demanding it, but you're providing the rationale for why you're asking for it, you present reasonably. This isn't a pie in the sky. You're not asking for a lottery ticket. You're asking for something very reasonable. And I think you could have a reasonable conversation and be successful in negotiating that as a result.
Great. Next question is, can you ask for your personnel file on a regular cadence? In other words, yearly.
Yeah, absolutely. You can either ask to see it or you can ask in writing and get copies of it. You can do whatever. Yes, I encourage people to do that. As I said during this little chat, I think it's kind of like your credit report. I think you should check, maybe even check every 6 months and see what's in there. Be friendly with the HR person.
Without a doubt. Next question. Do you need a record of previous written complaints in order to bring up mistreatment when leaving a company?
A record of previous written complaints in order to allege that you were mistreated? No, it doesn't need to be in writing, if that's the question.
Yeah, the question is, do you need a record of previous written complaints in order to bring up mistreatment when leaving a company? In other words, if you've been mistreated at a company, if I understand this.
No, you don't. However, if you don't need, it doesn't need to be. I mean, sometimes people don't complain. They're being harassed. They just want to like it to go away. They want to do their job, and so they don't say anything. It's not ideal, but sometimes you're kind of stuck between a rock and a hard spot. It'd be nice if you kind of told HR that you had this problem, so there would be a record that you had complained. That ideally should happen, but it doesn't prohibit you from bringing a claim. It doesn't denigrate or dismiss the fact that you have been harassed and you do have a legal claim. It may make it more difficult to prove it, but it doesn't mean that you shouldn't investigate it and check it out and see if you can get some leverage from having experienced that or been subjected to that mistreatment.
Great. Next one. What do you tell recruiters if they specifically ask you if you received a severance when you exited the other company, understanding that confidentiality is often required?
Say that one more time. So they
The
want to know
question is,
tell the
what do
recruiter.
you tell recruiters if the recruiter says, "Did you receive a severance from your last company?" What should you say, given what you said prior, Catherine, about these are confidential agreements? If you're asked by a recruiter, "Did you receive severance from the last company?"
Your severance agreement might prohibit you from sharing that information from the recruiter. It's very specific about who you can speak to. We didn't talk about that during the agreement, but the webinar. But it is very specific about who you can reveal the amount of money that you received with. It's usually your lawyer, your spouse, your accountant. It's usually limited to just that.
And so the response would be, "I'm not able
I'm not
to."
at liberty to share that with you.
Got it.
Mhm.
Thank you very much. Next one is, how would you address IP, co-ownership rights, intellectual property, co-ownership rights in a severance or termination agreement?
I would say very carefully. I had a client who had some patents before he started at the company, and then when he signed off, he wanted to make sure that he still owned those. But because we were careful on the front end to articulate them, it really wasn't an issue. But yes, be sure it's very clear that you own those and you're taking those with you.
Mhm. Next one, in the event of a merger or buyout,
Mhm.
especially during the pandemic, what's typical or reasonable or possible for termination or severance or stay bonus conditions?
It really depends upon how long they were there and what level of employee they were. Depends on an awful lot of factors. You mean, sounds like somebody's asking, like, so if they offered me $10,000, should I take it? Is that what the question is? I don't know what the question is.
Not sure. I think that person might want to reach out to you directly.
Yeah.
This is
Yeah.
very complicated. We are grateful for all that you're sharing.
Sure.
That's the whole point here. Is there is a lot of things that people don't know.
It's
Uh,
true. It's really true. And it's so easy to get help. Really. Just call.
and we're
Call your friendly lawyer and get it figured out. Yeah.
you've already answered a lot of questions for Anderson alums and worked with a lot of Anderson alums and Stanford alums where you're from, but this is complicated. It changes from year to year. Is that correct? A fair amount, and it's hard to keep up with.
Yes, the laws do change. The laws do change. Yes, they do. They do indeed.
Okay, next question. We're almost at time. We had about 5 minutes.
Yeah.
What's the time frame for that an employee can pursue the employer on a discrimination case? Is it years? Is it decades?
It's 3 years. It's
3
3 years. I mean, don't quote me on this. I mean, tell me what sometimes you think you have a discrimination case, but you have something else. But I believe that you now have 3 years to file a complaint with the DFEH for unlawful discrimination, harassment, or retaliation at work. They just changed the rule, the number.
Great. I've got your slide up. I'm going to end this in just a few seconds. I don't know are you able to see the Q&A in your screen, Catherine?
No.
Okay, good.
Oh, I could
I'm going to keep it
click on it,
confidential here, but we'll do a share screen in just a second. A lot of these questions we're talking about are layoffs. For new contracts, how do you broach this subject if they try to avoid it? Where can we find a good example of an employment contract?
Oh, on the internet, you could just look for employment contracts, but that's kind of
California
like,
specifically.
yeah, I mean, that's a little bit like LegalZoom. I mean, you could do that, it's a little bit like you get what you pay for too.
Right.
So I would kind of be careful with that. There's a lot riding on that. So it's not like I think it's worth investing the time to be sure it's done properly.
Sure. Sure. Is severance usually a lump sum as opposed to continued salary? How does that usually break down with the clients you work with?
Often it is, it's often a lump sum with the larger companies who are trying to figure out ways to avoid paying unemployment. That's what they're doing. They're dragging it out so that the language in the agreement is that once you accept a new job, you get the rest of your severance. And the thinking, I think there is, it's very clever, but it's not so nice, is that if then they become unemployed, there's someone else's on someone else's unemployment account versus company A's account.
Last question. We had so many great questions today. In your experience, how hard is it to get anti-dilution clauses added when you are receiving equity?
I would have to see the agreement.
Fair
Yeah,
enough.
I think you can negotiate for a lot more things than you think you can. That's my personal opinion.
Mm-hmm.
So, but I really would like to see the anti-dilution clause that they're talking about trying to get added.
All right. We are toward the end of the hour. I'm having a little bit of problems on my screen here. What screen do you see? Do you see your particular slide there?
Like I see you and I.
Okay.
I think people can find me if they need to. Don't worry about the slide.
Let's do that. Here we go. We'll just do from current slide. There we have it. There's your contact information. So to all the UCLA Anderson alumni that are out there, thanks for all your great questions. Catherine, thank you so much for all that you shared today. We will have a copy of this on the Alumni Career Services website. Another thing to be aware of, we do have the ACT team, the Alumni Career Teams, and that'll be starting at the end of January. So be on the lookout starting in January for specifics about the Alumni Career Team. That's also on the Alumni Events calendar right now if you are interested in finding out more. But more than anything, and here we go, a little Adobe thing. Thank you so much, Catherine, for all that you shared, and thanks for being willing to talk for a few minutes to UCLA Anderson alums. We got a lot out of this. We're grateful for your partnership, and thanks for doing the webinar today, and happy holidays to you and to all out there in this very strange year in the middle of all this. So thanks so much for doing this webinar today.
It was my pleasure. Anytime. Happy to help.
Thanks again, and we will talk very soon.
Okay. Have a great holiday, everyone.
Catherine, you too. Bye now.
Bye-bye.